Ladies, my lords, in respect of the appeal from the inner house of the Court of Session, I would invite the court to recall the interlocutor of the inner house and to dismiss the petition. In addressing the court, I'm conscious that there are issues both of fact and law that require to be touched upon. And as my learned friend, Lord Pannick observed in his opening, it is intended that to a substantial extent, my learned friend, Sir James Eadie, will address the detailed aspects of the authorities and law applying in respect of justiciability. Nevertheless, it's a topic upon which I will have to encroach to some extent in order to complete my submissions. I also have to anticipate the case to be made in this appeal by my learned friend, Mr. O'Neill, and your lordships will have had the opportunity to see his written case that perhaps goes beyond, in some contexts, the decision of the inner house itself. So what I would like to do at the outset is to identify those areas, 3 areas, where we are in agreement with the decision of the inner house, or at least the majority opinion in the inner house. And the first matter that I would seek to address is this. The inner house accepted that the determination of this case does not depend upon the particular terms of the claim of right or any speciality of Scots constitutional law. That was the opinion of the Lord President to be found at paragraph 51 of his opinion, which is at MS 1209. Perhaps I could simply ask the court to note his observation that, albeit that there could be an issue as to whether or not an act was lawful or unlawful, this is not because of the terms of the claim of right 1689 or of any speciality of Scots constitutional law. It follows from the application of the common law informed by applying the principles of democracy and the rule of law. And he refers there to the Lord Hodge in the case of Murn. To the same effect is Lord Brodie at paragraph 81 of the inner house judgment, which is at MS 1226. And there he observed that there had been no contravention of the claim of right, which was part of the case which had been advanced on behalf of the petitioners. And indeed he observed about halfway down that paragraph that while we heard much from Mr. O'Neill on behalf of the petitioners, which was both interesting and stirring about a particularly Scottish tradition of holding the crown in its various manifestations to account for present purposes and not having actually identified any material differences between the applicable Scots law and the corresponding English law, Mr. O'Neill was to an extent pushing at an open door, however only to an extent. Lord Drummond-Young didn't address the matter directly in the same way as the Lord President and Lord Brodie, but your lordships may note that in his opinion at paragraphs 97 and 98, which can be found at MS 1237, he refers to the constitutional system of the United Kingdom. Now, that is hardly surprising, I venture, when we're dealing with the prerogative powers which may be exercised with respect to the Parliament of the United Kingdom. And indeed, also when we come on to consider the privileges of that United Kingdom Parliament. And I note, and your Lordships may have seen this already, that this is also consistent with the written case submitted for the Lord Advocate in footnote 6 of that case. I'm afraid there are no MS references that I'm aware of. He notes, however, the prerogative at issue here is the power of the Crown in right of the United Kingdom to prorogue the United Kingdom Parliament. The legal content and effects of that prerogative cannot sensibly differ as between the different jurisdictions of the United Kingdom, nor at the level of constitutional principle, should there be any difference of approach between the different jurisdictions of the United Kingdom as regards the proper role of the court in reviewing the exercise of that prerogative. The important thing is that the correct approach should be taken in that regard in both jurisdictions. Now, for reasons which I'll come on to elaborate, I would simply wish to refer the court to some authority that underpins the proposition that in addressing the prerogative as it applies to the United Kingdom Parliament and considering the privileges of that Parliament, one has regard to common principles of public law throughout the United Kingdom. I just note in passing that the matter was addressed in the case of Burma Oil against the Lord Advocate as long ago as 1965, when the court observed that it would be highly unusual, if not surprising, if the application of these matters differed as between the north and the south bank of the Tweed. I would also refer to the case of Adams against Guardian newspapers, which was an outer house case in which the judgment was given by Lord Reed. That can be found at MS 1325. And there, at paragraph 13 of that judgment, Lord Reed observed as follows: there is little modern authority in Scotland on the issue of parliamentary privilege, but it was common ground before me, and it appears to me to be clear that the law on this matter is in general at least, and subject to any divergence arising in consequence of other differences between Scots and English law, e.g. as to procedure, the same in Scotland as elsewhere in the United Kingdom. No difficulty arises in particular from the fact that the Bill of Rights was passed by the Convention Parliament in England and had its Scottish equivalent in the claim of right, the latter being less specific on the issue of freedom of speech. As Mitchell, in his work on constitutional law, explains, doctrines of parliamentary privilege were more fully developed in 1707 in England than in Scotland, and it was therefore natural that the greater should be accepted as the basis of the privileges of the Union Parliament, quite apart from the natural tendency of that Parliament to refer to precedents which were familiar to the majority of its members. And that judgment was in turn approved in the case of Coulson against Her Majesty's Advocate, a decision of the High Court of Justice, essentially the equivalent of the Criminal Court of Appeal, in 2015. I should say that there are also echoes in my Lord Reed's observations of the evidence which the late Lord Roger, in his capacity as Lord President of the Court of Session, and Sir Robert Carswell, in his then capacity as Chief Justice of Northern Ireland, gave to the Joint Committee on Parliamentary Privileges, where they made clear that they were convinced that the law would be interpreted in Scotland and Northern Ireland to reflect closely the interpretations placed upon parliamentary privilege by the English courts. So it is quite clear that the decision in the Inner House and the divisional court decision in Miller did not result from any substantive difference between English law and Scots law, because as the Inner House held, in this context, there simply wasn't any such difference to be relied upon. My lady, my lords, the second matter of agreement with the Inner House is that the prorogation of Parliament does not have a direct consequence on individual rights. And the Inner House rejected the petitioner's argument that the issue was rendered justiciable on that basis. The Lord President addressed the matter at paragraph 59 of his judgment, which can be found at MS 1212. And really very briefly said, however, the proroguing of Parliament does not have a direct consequence on individual legal rights. The issue is not justiciable on that basis, and the petitioner's argument to the opposite effect on this point is rejected. And again, Lord Drummond-Young, at paragraph 125, which is at MS 1253, simply observed, finally, I should express concurrence with the views of your lordship and the chair on the question of redaction of documents supplied and the proposition that proroguing Parliament does not have a direct effect on individual legal rights. So again, I seek to put that issue to one side, albeit it may re-emerge as my learned friend Mr. O'Neill presents his submissions to the court in light of his written case. The third matter of agreement with respect to the Inner House is the acceptance by a majority of their lordships that a principle of non-justiciability exists in public law and that whether an issue is ultimately justiciable will depend upon the subject matter. And that can be found, first of all, in the opinion of the Lord President at paragraph 50, which is at MS 1208. Where he observed the decision under review, which seems to be made by the Prime Minister alone, is that to request Her Majesty the Queen to exercise her prerogative to prorogue Parliament. A prerogative decision may be the subject of a judicial review, reference to Bangkok. Whether the issue is ultimately justiciable will depend upon the subject matter, and a reference there to Lord Scarman and Lord Roskell in the GCHQ case. To similar effect, we find Lord Brodie at paragraphs 83 to 85 of his opinion. That's at MS 1226. And I won't seek to take your lordships through the entirety of that passage, but again, he appears to approach the matter on the basis that there may be an issue of non-justiciability and that it will be determined by reference to the subject matter of the case. In particular, at paragraph 84, he also made reference to the Sandiford decision that was mentioned by my learned friend, Lord Pannick. I should add, however, that Lord Drummond-Young dissented on this point, and I simply ask your lordships to note that that can be found at paragraphs 102 to 103 of his opinion, which is at MS 1240. But looking to the majority decision in the Inner House, again, on this third point, it is clear that the Inner House accepted the principle of non-justiciability in public law, and that ultimately justiciability would depend upon the subject matter before the court. And that, I would venture, is clearly consistent with extensive authority, which is set out in our written case, essentially from paragraph 55 onwards, and which my learned friend, Sir James Eadie, will address in due course and in more detail. So again, I put those three issues to one side at this stage. The next point that I would seek to address with the court concerns the interlocutor pronounced by the Inner House on the 11th of September this year. And that can be found at MS 505. And if I might refer the court in particular to part 4 of the interlocutor, which was pronounced after they had reversed the decision of the Lord Ordinary and allowed the reclaiming motion. And it is in these terms: find and declare that the advice to prorogue Parliament on a day between 9th and 12th September until 14th October 2019, and hence any prorogation which followed thereon, is unlawful, and thus null and of no effect, and discern. Now, insofar as the Inner House seek to declare the prorogation unlawful, I will take no issue with their order. But insofar as they purport to declare that prorogation is null and of no effect, I submit that they've simply gone where the court could not go. As your lordships will be aware, prorogation may be by the sovereign in person. That has not happened in recent years. I believe the last sovereign to prorogue Parliament in person was William IV. But alternatively, it may take place by Lords Commissioners acting on a commission from the sovereign. Those Lords Commissioners summon the House of Commons and the Speaker of the House of Commons to the upper chamber and declare under the authority of the Great Seal that Parliament is prorogued. These are proceedings in Parliament, and consistently with the law of parliamentary privilege, which is common to both England and Scotland, such proceedings should not be impeached in any court. And in that context, of course, I would make reference to Article 9 of the Bill of Rights, which for reference can be found at Authority 43, MS 2893. And I would also refer to the claim of right, albeit its wording is rather different and less direct, which is in the Authorities Bundle at 44, MS 2902. So my submission at this stage is that on any view, Part 4 of the Inner House interlocutor must be recalled. And I understand
it's quite a difficult concept, isn't it, Lord Keane? This is unlawful, but it's valid.
It is because the courts are not to cross the boundaries and intrude upon the proceedings in Parliament. They may make the appropriate declarator, and I would take up a point mentioned towards the end of his submission by my learned friend, Lord Pannick. If this court finds that the advice of the Prime Minister was unlawful, the Prime Minister will take all necessary steps to comply with any declaration made by the court. And that is the appropriate way in which this matter should be addressed.
Well, that dispenses with the problem, you might say.
Well, indeed. And I understand that, in fact, the Speaker's Council have advised that as far as they're concerned, Parliament is prorogued at the present time, and it is to dispense with any debate over that issue that I draw particular attention to Part 4 of the Inner House Interlocutor, because it did actually generate debate as to whether or not Parliament should or should not be sitting at the present time.
We have got an awful lot to think about in this case, have we not, Lord Keane?
Indeed.
And whether this is or is not a proceeding in Parliament seems to me to be an extremely difficult question.
But it is, if I might venture, my lady, perhaps one that we can essentially put aside if the court is willing to accept the
That's what you're suggesting
undertaking
that we do.
that I have given on behalf of the Prime Minister.
It may be necessary just to hear the refutation of your point before we decide to put it to one side. We'll wait and see.
Very well. I
I appreciate that the activity takes place in the Houses of Parliament, but that in itself is not enough to turn it into a proceeding in Parliament.
As I indicated, my lady, I would submit that the conduct, whether it be of the Sovereign, of the Lords Commissioners, are proceedings in Parliament and should not be questioned by the court. But it may be that we can allow further debate on that issue in light of the undertaking which I am prepared to repeat on behalf of the Prime Minister and indeed the Executive.
What's the effect of the undertaking? What happens if this court does declare the prorogation unlawful? Does Parliament then reconvene?
It will be then for the Prime Minister to address the consequence of that declaration and to consider...
What other consequence could there be?
Well, the consequence could be that he goes to the Queen and seeks the recall of Parliament.
He has other alternatives, you say, does he?
Well, as I say, I have given a clear undertaking that the Prime Minister will respond by all necessary means to any declaration that the original prorogation was affected by any unlawful advice that he might have given for the purposes of the original prorogation.
Can we take it then he wouldn't apply to have Parliament prorogued again?
I'm not in a position to comment on that proposition at all, my Lord.
That's why I'm personally very interested in what you say the effect is, because abiding by a declaration conjures up a number of possibilities.
That will have to be addressed by the decision maker, my Lord.
It would be helpful to have the undertaking or given in writing, so we're absolutely clear what you're...
Well, I'm content for that to be done, my Lord. As I say, the terms of the undertaking I give is that if the court finds that the advice of the Prime Minister was unlawful, the Prime Minister will take the necessary steps to comply with any declaration made by the court.
That's slightly different from the order of the Scottish Court, which was not that the advice was unlawful, but that the prorogation was unlawful. I mean, are you accepting that if the advice was unlawful, then the prorogation is unlawful?
The position, as I understand it, is that the complaint from the petitioners is that the advice given to Her Majesty was unlawful, because the decision...
Yes, I understand that.
Because the
The
decision
order
of Her Majesty to prorogue cannot be impugned.
Well, for my part, it'd be helpful if between you and Lord Panic you can work out and give us a clear formulation of what you say you're prepared to undertake.
Well, I'm content to speak to my learned friend Lord Panic to see if we can agree a form of word in that sense.
Without that, we would have to rule on your Bill of Rights point.
Indeed so.
If I'm not prepared to respond to Lord Kerr's question, that there's no undertaking not to prorogue again, will the undertaking give Parliament an opportunity to decide whether it wishes to pass any legislation before that happens?
Well, my lady, it must be for the decision maker to consider the declaration made by the court and to ensure that he proceeds lawfully thereafter.
Thank you.
Can I ask Lord Keane what the status is to be of the order in council granting prorogation,
Well,
or ordering prorogation?
the order in council is the instrument by which the Lords Commissioners are engaged to prorogue Parliament, but it is merely an instrument for that purpose. It is possible for an order in council to be impugned. I quite accept that, and there is authority for that proposition. Doesn't follow that all orders in council it can be impugned.
Now, are you saying that its effect is spent?
It would be spent in those circumstances, my lord, yes, because the order in council directs the prorogation from a particular date to another particular date. Sometime between the 4th and 9th of September and the 14th of October of this year. Lords, the focus of the submissions that I now make will be on the detailed reasoning of the Inner House at the Court of Session, in the context of the Inner House having agreed with the principle of non-justiciability in public law. What the Inner House then sought to do was to apply an exception to that principle. And I will submit that they then erred in the inferences which they drew from the circumstances of the case before them. And I would observe that these are inferences that the Lord Ordinary, who heard this case at first instance, was not prepared to draw. Furthermore, I venture that an examination of the inconsistent reasoning in the three Inner House opinions tends to reveal the very absence of manageable judicial standards for the exercise that the Inner House purported to carry out. The Inner House sought to apply what they regarded as a proper purpose or improper purpose to the exercise of the prerogative of prorogation. Various terms were used in the opinions of the Inner House: formal purposes, standard use, proper purpose, intended scope. But as we seek to set out in some detail in the written case at paragraph 87 through to 90, the prerogative of prorogation is not exercised for one or more limited purposes. And I would submit, for the reasons explained in the case at paragraphs 88 to 90, that an improper purpose doctrine or test has no sensible application to the exercise of the prerogative power of prorogation. The determination of what are proper and improper purposes, for which, for example, statutory powers can be used, depends clearly on identifying the policy and objects of the relevant statute. And my learned friend, Lord Panic, made reference to the case of Padfield. That, as Padfield makes clear, is a question of statutory construction, and I would submit that no similar exercise can be conducted in respect of the prerogative power of prorogation, as opposed to, for example, a power exercisable under a prerogative instrument. And we know that Parliament may be prorogued for a variety of reasons, political as much as formal. And certainly, the power to prorogue Parliament is not in any sense limited to the preparation of a new Queen's speech. That was a point which the Divisional Court made very clear in its own judgment, and I refer there in particular to its judgment at paragraph 55. Indeed, the Divisional Court went on to observe that even if one was looking only at the matter of the provision of a new Queen's speech, it was not for the court to determine how much time might be contemplated as necessary or required, even for that purpose alone. In the course of his submissions, my learned friend Lord Panic did not make reference, as I recollect, to the Prorogation Act of 1867. And I wonder if I could just draw that to the court's attention. It's in the Petition Authorities bundle at tab 48 and can be found at MS 2922. Just looking very briefly at the provision of section 1, whenever Her Majesty shall be pleased by and with the advice of the Privy Council of Her Majesty, in this context, of course, the Prime Minister or the Executive, to issue her royal proclamation to prorogue Parliament from the day to which it shall then stand summoned or prorogued, to any further day being not less than 14 days from the date thereof, such proclamation shall, without any subsequent issue of a writ or writ patent or commission under the Great Seal of the United Kingdom, be a full and sufficient notice to all persons whatever of such royal intention of Her Majesty. And the Parliament shall thereby stand prorogued to the day and place in such proclamation appointed, notwithstanding any formal law, usage, or practice to the contrary.
But that isn't what happened in this case.
That is not what happened in this case, but the point, milady, is simply this, that Parliament has made express provision that where Parliament stands prorogued, it may be prorogued for a further period of at least 14 days, by exercise of the prerogative. And that is not, on the face of it, related to a Queen's speech. And indeed, if you go on to section 2 of the Act, it provides this Act shall not apply to the case of the prorogation of Parliament at the close of a session.
What was the purpose for the prorogation in this case?
I'm going to come on to address that in some detail, my Lord, because various assertions have been made touching upon the proposition of improper purpose, and various inferences have sought to be drawn which are adverse to the purpose which was put before the court. And therefore, as I say, I will come on to address that in some little detail. But before I go there, can I just take this a stage further? Because there are clear examples of where the prerogative has been exercised for political reasons, rather for formal reasons, and indeed for extensive periods of time. And my learned friend, Lord Panic, said, yes, but these were of some vintage, as it were. given that he's seeking to found upon principles of constitutional law that have developed presumably over the last 300 years or so since the Bill of Rights, it doesn't seem to me inappropriate to look at how the matter has been addressed in the interim. And if, perhaps most conveniently, your lordships can refer to our written case at paragraph 71. And I regret there seems to be no electronic numbering for the case. And just put in context, at the beginning of paragraph 70, it's observed, in giving advice on prorogation, the Prime Minister will necessarily take into account matters that are political. And it goes on, the history of the power to prorogue Parliament supports the fact that it has been used for political purposes, including for the purpose of restricting the time otherwise available to debate legislation and for prolonged periods, including at moments of political importance and when the government of the day lacked a majority in the House of Commons. And the first example is given in respect of September 1914, shortly after the outbreak of the First World War, where Parliament was initially prorogued until 27th October, with the King's speech on prorogation noting that the circumstances, and I quote, call for action, not speech. And on 16th October 1914, Parliament was further prorogued by proclamation until 11th November 1914. And that clearly was not for the purpose of a King's speech. And then the second example, on 1st August 1930, Parliament was prorogued until 28th October, a period of 87 days, and this was during the onset of the Great Depression following the 1929 Wall Street crash, when the new government of James Ramsay MacDonald did not command a majority in the House of Commons. And again, that was clearly not for the purpose of delivering a King's speech. One might observe, rather, that it was clearly so that the executive could avoid unnecessary scrutiny in circumstances where they did not, on the face of it, command the confidence of the House. And then the third example, which was touched upon by my learned friend, was the case in 1948, where under Section 2 of the 1911 Act, a non-money bill could only be enacted without the consent of the Lords if it was passed in 3 successive sessions by the Commons. As noted below, each session of Parliament conventionally lasts for approximately a year. To facilitate the speedy passage of the Parliament Act 1949, the government arranged for a session of minimal length in 1948. Parliament was prorogued on 13th September 1948 to the following day. Following the passage of the Parliament Bill by the Commons, it was then prorogued again on 25th October 1948. The King's speech, which closed the session, expressly noted that the two houses have again failed to agree on the bill to amend the Parliament Act 1911. Now, this last example was clearly for a party political purpose. It was carried out in order that the then executive could avoid scrutiny of its legislation in the House of Lords, potential defeat in the House of Lords, and ultimately in order that it could overcome the opposition of a majority in the House of Lords for the passage of its intended legislation. And to describe that as somehow some formal use of prorogation is very far from the truth. It was clearly a naked political use of prorogation by the executive to essentially force through Parliament its intended legislation, notwithstanding the knowledge that it had no consent of a majority in the House of Lords in order to achieve that political objectives.
But of course it could be said, could it not, and Lord Keane, that it was in order to enforce the will of the House of Commons, that is the democratically elected will of the House of Commons, and thus in pursuit of democracy rather than against it. It could be said.
Well, I would take issue with that, my lady, particularly if one examines the circumstances which pertained in Parliament in 1948. The 1911 Act was passed in its form for a reason, and that was to allow the House of Lords the opportunity to also take part in the passage or otherwise of
I'm aware of that,
affirmative
Keane, but
legislation, clearly.
It could be said that this was the House of Commons asserting itself against the House of Lords. That is the democratically elected House of Parliament against the then, at that stage, wholly hereditary House of Lords. Apart from the Law Lords.
Indeed, so, my lady. Well, in fact, at that time, the Law Lords would have been hereditary as well, would they
No.
not? Unless they were appointed under the 18...
They were the first life peers.
They were the first life peers. My lady's quite right. But with regard to this matter, it's quite clear that even if one attempts to drill down into what happened in 1948 or 1930 or 1914, prorogation is not being employed here for formal purposes, for standard purposes, or for non-political purposes. It is clearly being employed in circumstances where the executive wished to pursue a particular political objective, and they are entitled to do so. Now, the Inner House does very little to expressly address this issue, but it is clear that in taking its own approach to the exercise of the prerogative of prorogation, I apologize, that it is seeking to apply what might be regarded as an improper purpose test. And one sees that in the opinion of Lord Drummond-Young at paragraph 104. I won't necessarily take your lordships to all of these references, but if you note them, it's at MS 1242, where he talks about the exercise of the prerogative in this case as being out with its intended scope, without actually defining its intended scope. And again, at paragraph 106, which is at MS 1243, he refers to proper purposes. At paragraph 108, he refers to its standard use. That's at MS 1243. And then goes on to refer to its formal purposes at MS 1244. He does refer to the circumstances of the Parliament Act 1949, but observes simply that this cannot serve as a precedent. Well, with respect, it is a clear example of the prerogative being exercised with a clear political aim. And what one can take from these examples is that the exercise of the prerogative is clearly not limited to some formal or standard purpose, with the result that where it is employed elsewhere, one can infer some improper purpose. Despite that, Lord Drummond-Young at 116, which is at MS 1248, goes on to require what he refers to as a valid reason. Now, if the court requires a valid reason, then it would surely require to identify an invalid reason, and in particular, an invalid political reason, because it's quite clear that the reasons for seeking to exercise the prerogative of prorogation may be political rather than formal. And in the same vein, the Lord President at paragraph 50 of his judgment uses the language of, and I quote, legitimate political considerations. And again, if we go down that road, it will require the court to identify what is an illegitimate political consideration. So the effect of the Lord President's language is to apply a political purpose test. of some kind. And then Lord Brodie, at paragraph 91 of his opinion, refers to what he termed egregious illegality as an improper purpose case. So again, we have reference to purpose, political purpose, legitimate or illegitimate, as being the touchstone, apparently, for the courts to address this matter. But as was noted by the court in Padfield, one cannot test propriety of a purpose which has not been conferred by a particular statutory scheme. Because without the statutory scheme, you have no yardstick against which to measure whether the exercise is proper or improper.
Well, say for example, honours were being granted on the basis of bribery and corruption. I don't imagine there's any statute that governs the award of honours. Would that not be, on any view, improper?
It might be improper, but the remedy would lie in the political field and the other legal requirements with regard to bribery and corruption.
But could it not be declared unlawful? Take my Lord's example.
It appears to me that to do that, the courts would have to impinge upon the exercise of the prerogative in an area which is not justiciable, and therefore, no, it could not be declared unlawful by the courts.
Unless it was a breach of the criminal law.
Well, that's a different matter. If the matter was brought on the basis that there was to be a prosecution, then clearly the courts engage in that. If the matter was to be brought on the basis of a civil claim arising out of that. But in the context of the actual exercise of the prerogative, that could not be impugned. And indeed, it raises a point that was touched upon in the Inner House, because the court raised the question of what would happen if it appeared that the advice to prorogue Parliament had been secured by bribery. About the most extreme example that could be thought of. And in my respectful submission, the remedy for that would lie in regard to the penalties for bribery and corruption, and would lie in the political field in respect of those who'd engaged in it. But it would not render the exercise of the prerogative amenable to justiciability before this court. That would be to ignore the boundaries set out with respect to the separation of powers. Where Parliament wishes to determine when it does not wish to be prorogued, then Parliament, can and indeed does address this by primary legislation. The legal limits on the power of the executive are, in other words, set by Parliament and not by the courts, insofar as it concerns the exercise of the prerogative to prorogue. And there are, of course, a number of examples of where Parliament has exercised that right of control by the use of primary legislation. And examples are given in the written case at paragraph 28. But shortly put, they include section 5 of the Succession to the Crown Act, 1707, which can be found at MS 2917. Section 52 of the Reserve Forces Act 1996, which can be found at MS 2925, and Section 28 of the Civil Contingencies Act 2004, which can be found at MS 2927. In each case, Parliament has applied controls upon the executive with regard to the circumstances in which it may or may not be prorogued according to particular circumstances. But of course, the most recent example of this can be found in Section 3 of the Northern Ireland Executive Formation Act 2019, and in particular Section 3 of that Act, which emerged as a result of the amendment in the House of Lords by David Anderson QC, Lord Anderson of Ipswich, to introduce a mechanism whereby Parliament could require to be recalled for certain periods and at certain intervals between September 2019 and 31st October 2019, indeed going on to December 2019, in circumstances where it was either prorogued or adjourned by reference to recess being what appears to have been contemplated.
Where do we find Section 3?
MS 2951, my lady.
Thank you.
And there's a detailed analysis of its terms set out in the written case as well. And I'll come on to it in a little more detail, if I may, in a moment. But when the Inner House came to address the provisions of that Act, it appears, in my respectful submission, that the majority fell into error with respect to the provisions of Section 3. Lord Brodie, however, and this was at paragraph 72 of his judgment, which is at MS 1220, correctly held that the business which Parliament addressed when sitting pursuant to Section 3 would be for Parliament to determine, because it was going to sit for a period of 5 sitting days at certain intervals as a consequence of a report being required to be made to Parliament concerning the formation or otherwise of a Northern Ireland executive at Stormont. Lord Drummond-Young, by contrast, and this was at paragraph 114 of his judgment, MS 1247, suggested that the sittings of Parliament pursuant to Section 3 of that Act would be limited and related to the formation of an executive in Northern Ireland. There is, with respect, no such limitation in the Act, and indeed it might be difficult to conceive of circumstances in which Parliament would have to debate the non-formation of a Northern Ireland executive for 5 days. The Lord President took a similar view to that of Lord Drummond-Young, and at paragraph 56 of his opinion, at MS 1212, suggested that the Act was designed primarily to relate to the formation of a Northern Ireland executive. Now, I venture that Lord Brodie was clearly correct in this context. When Parliament was legislating for a period encompassing the exit date, with 5 days of debate for each of those occasions, it clearly, I suggest, had in mind the exit date itself of 31st October 2019. But perhaps the most notable aspect of Section 3 of the Northern Ireland Executive Formation Act is that from its terms we can clearly discern that Parliament anticipated that it might be prorogued or adjourned in the period between September and 31st October 2019 and legislated accordingly. If Parliament had not intended or wished to be prorogued or adjourned for longer than the period specified in Section 3, then it could and presumably would have said so. But I venture that it is not for the inner house of the Court of Session to say to Parliament that over and above what Parliament has determined by primary legislation as to its sittings in that period, the Court considers that they should be sitting for longer.
Whilst we've got section 3 out, once the first report's been laid, there's an obligation to lay a subsequent one. And in that circumstance, it has to be laid before each House of Parliament by the end of the day on which it's published. So there has to be by the 9th of October. Is there going to be another sitting for that to happen?
I understand that the next sitting would be on or after 14th October. Because as I understand it, under parliamentary procedure, the report is deemed to be laid when Parliament returns.
That wouldn't be within the period, would it?
Well, that is the view, certainly, that has been expressed. There may be an alternative view, but that certainly is the view that has been expressed, that under parliamentary procedure, the report made would be deemed to be laid on the day Parliament returns.
Thank you.
But I'll take steps to check that if I may.
That would be helpful.
Because,
Thanks.
Well, it would have to be deemed to be laid on or before the 9th of October to comply with section 3, subsection 5.
Wouldn't be regarded as laid during recess.
No, it wouldn't. So what you're saying is that somebody has said to you that once Parliament returns on the 14th and it's then laid, this is deemed to have been laid on the 9th. That's what you're telling us.
No, I don't believe I am. I'm saying that where the statutory provision provides for the laying of the report, it may be produced on the 9th, but under parliamentary procedure, it will be regarded as having been laid on the 14th in order that the relevant...
But the problem is that that doesn't comply with the timetable in the statute, because it has to be a report on or before the 9th of October, and then it has to be laid by the end of the day on which it's published.
But it's the latter point, by the end of the day, as I understand it, and I will take steps to check this, but the report would be made on the 9th of October, but it would actually be regarded as laid when Parliament returned from recess.
Okay.
And that would be regarded
I'll leave it.
in that context as the end of the day, but I will take steps to confirm that.
So is the report published on your understanding on the 9th, but treated as laid on the 14th?
That is my understanding, my Lord.
Notwithstanding that the initial report quite clearly must be laid before Parliament on the end of the day on which it's published.
Indeed so. And it's the use of the term the end of the day in the context of Parliament potentially being in recess, for example.
No, on the end of the day on which it is published.
I quite understand the difficulty, my Lord, and the provision has been looked at.
Well, I'd welcome. I know your time limits. Your time is limited, but I'd welcome some clarity on this, perhaps later on.
Can I indicate to the court that I will return to that in my reply once I've clarified what the position is understood
Thank you.
to be? But that is my understanding of the position at the present time. The point that I seek to make in the context of Parliament having passed Section 3 of the 2019 Act is this. Parliament had the opportunity and the means to determine where and when it would and would not be prorogued or adjourned in the period from September up to, indeed, December of 2019. If Parliament had wished not to be prorogued or adjourned for any longer period in that period or in that time, it would have been able to address that matter itself by way of primary legislation. It did not do so.
Subject to the
This
consent of
act
the sovereign.
came into force on the 24th of July. Was there any suggestion from any official source on the 24th of July of any intention to prorogue Parliament over a period which included the 9th of September?
Milady,
No, sorry, 9th of October.
Milady, that must have been anticipated because that explains the wording that was employed in Section 3 of the Act.
But
Parliament clearly anticipated that it might be prorogued or adjourned over that period. That is the whole purpose of Section 3. If we are prorogued or if we are adjourned, then we demand to be recalled. And that is the mechanism that Parliament determined should apply. If there had been no contemplation in anyone's mind of Parliament being prorogued or adjourned, it is difficult to conceive of how Section 3 would have emerged into the Northern Ireland Executive Formation Act. The latter being what might be termed a convenient vehicle for the amendment that was introduced in the House of Lords in order to introduce what is now Section 3 of the Act. But what I say is it is quite clear from the terms of Section 3 that Parliament did contemplate that it might be prorogued or adjourned during the relevant period. That must be the case.
If one proceeds on the premise that there was inaction by Parliament when action could have been taken, what is the significance of that?
Well, the significance is this, that if and when Parliament does not wish to be prorogued by exercise of the royal prerogative, Parliament controls that process by means of primary legislation. The issue is determined by Parliament. It is not determined by the courts. Parliament having determined the issue by using primary legislation, we now have the court coming forward and saying, notwithstanding this, we in turn wish to overlay your primary legislation with a requirement that Parliament should sit for longer. And I say that's a simple intrusion into the position of Parliament, and it's a decision that does not respect the separation of powers.
Is it not possible that Parliament did not anticipate in July that there would be a prorogation of 5 weeks?
Well, I'll come on to the period of the prorogation in a moment, if I may, my lady, but assuming that was the case, when Parliament was sitting at the beginning of September, it then proceeded to pass the European Withdrawal No. 2 Act, which determined that essentially the executive should not proceed to exit the European Union without a deal and should instead secure an extension. And if at that stage Parliament considered that it needed to ensure that it would not be prorogued or adjourned for a longer period, it had the means to do so. That bill passed Parliament in 2 days. So whether it be the Northern Ireland Executive Formation Act in July or later, the legislation that formed the European Union Withdrawal Act No. 2, the fact is that Parliament had the means to secure whether it would or would not be prorogued or adjourned during a period up to and including 31st October. Parliament exercised its ability to set the limits on the power of the executive to use the prerogative to prorogue Parliament. And having set those limits, it is not in my submission for the courts to overlay that primary legislation with their own views to when Parliament might or might not sit. That is to intrude over the boundaries of the separation of powers. There are more than adequate mechanisms to determine limits upon the exercise of the prerogative prorogation, but they are exercised by Parliament using primary legislation. So that being the position, if I can move on slightly, I pose this question. How then did the Inner House come to hold that the exercise of the prerogative to prorogue Parliament could be challenged? As I noted earlier, the majority, namely the Lord President, get me some water, and Lord Brodie, recognised the principle of non-justiciability founded upon the subject matter test. And as I also noted, the Lord President held that decisions that are made on the basis of legitimate political considerations are not justiciable. Lord Brodie suggested that justiciability could depend upon the particular circumstances of an individual case. That was his opinion at paragraph 84, and particularly where the case was, as he described it, extreme or egregious. But that, of course, is not the subject matter test, which he's previously acknowledged is the relevant test to apply in the context of justiciability. The subject matter test is applied by reference to the nature of the power, not the facts of the individual case. That, I submit, is clear from the authorities that my learned friend Sir James Eadie is going to come on to address. And I hesitate before, as it were, trampling on that ground, as it were. Now, clearly, the exercise of the prerogative in respect of prorogation, or indeed dissolution prior to the Fixed Term Parliament Act, is a matter of political judgment. And one cannot dismiss the position with regard to dissolution simply because of the emergence of the Fixed Term Parliament Act. Again, if my learned friend Lord Panic is praying in aid a constitutional tradition that embraces principles that have essentially emerged over 300 years, then I believe we're entitled to look at what has happened during that period. And one thing that has clearly emerged is the belief by the courts that the matter of dissolution of Parliament is preeminently not justiciable. Now, of course, I accept matters have moved on since Lord Roscoe spoke in GCHQ, but that remains a constant theme. It has always been identified as one of the paradigm examples of non-justiciability. And one cannot dismiss that simply because of the Fixed Term Parliament Act. And the Fixed Term Parliament Act, of course, in turn, at Section 6, expressly preserved the prerogative of prorogation. Now, if, as the Lord President suggests in his opinion at paragraph 50, such a power is only non-justiciable when based on legitimate political considerations. How is the court going to be equipped to decide what these are, or indeed what they might even be? In my respectful submission, the Lord President has nakedly entered the political arena by going down this particular road.
Isn't he saying there political considerations which offend the law, rather than some political considerations are legitimate and some aren't?
In my respectful submission, he is quite clear. He uses the term legitimate political considerations. Yes. And that therefore raises the question of what are illegitimate political considerations, and how is the court equipped to judge the difference between a legitimate political consideration or an illegitimate political consideration.
It starts, I suppose, by being told what the consideration is.
Absolutely, and I'm going to come on to that in a moment, my Lord, and deal with that in a little detail, if I may. But let us go back to the principles. The Lord President accepts the principle of non-justiciability based upon the subject test. But he says the tipping point is that applies where a decision is based on legitimate political considerations. And I just underline that the court is not equipped to decide what is a legitimate political consideration and what is an illegitimate political consideration. And the matter is not really taken any further by Lord Brodie, where he suggests that the test is one of egregiousness. Again, no judicial standard is being provided. What is egregious in that context? What is shocking to one politician may be very less than shocking to another. Then at paragraph 51 of his opinion, which is at MS 1209, the Lord President sought to rely on what he termed, and I quote, the good governance principle. But again, what is this? If anything, it is a political aspiration. By what legal test do the courts purport to determine what is good as opposed to bad governance? Learned friend Lord Panic made reference to the case of Bancolt and the Secretary of State, which your lordships can find at MS 2282. I have it in the authorities bundle for this appeal at authority tab 32. I appreciate that these cases appear in more than one place, which is less than convenient, but I hope Milady will bear with me.
The important thing is that they appear at all and that somebody can tell us where to find them.
Well, indeed.
That's the only important thing.
Well, it's helpful if you stick to the bundle for the Inner House appeal, because they are much more easy to deal with.
Well, my difficulty is that in preparing my speaking note, I've had regard to the bundles that I had available to me, and those were the bundles in the Scottish appeal.
Well, but that's the helpful one.
Volume 2 in the Miller appeal, tab 23, I think, is Bancourt number 2. That's where we looked at it before.
But in that case, the majority of the court held that the Crown's prerogative power to legislate for peace, order and good government imposed no justiciable limitation on that power. And I would take the court in particular to the judgment of Lord Roger of Earlsferry at paragraph 109, which can be found at MS 2333. And it's in paragraph 109, towards the end of the page. Equally, he says, it cannot be open to the courts to substitute their judgment for that of the Secretary of State advising Her Majesty as what can properly be said to conduce to the peace, order and good government of the IOT. This is simply because such questions are not justiciable. The law cannot resolve them. They are for the determination of the responsible ministers rather than judges. In this respect, the legislation made for the colonies is in the same position as legislation made by Parliament for this country, as the High Court of Australia pointed out. In both cases, the sanction for inappropriate use of the legislative power is political, not judicial. The difference, and it is of course very important, is that orders in council are made without the concurrence of Parliament or of any other representative legislature, and so the political control is less direct. That lack of direct political control over them may well be considered undesirable in today's world. If so, the appropriate remedy is for Parliament, not for the courts, to get involved in scrutinising the substance of such orders in council. And again, Lord Carswell, at paragraph 130, MS 2340.
Before we move on from 109, isn't Lord Rogers' point really predicated on what he says at the start of 109? He's making a very technical point about the scope of the powers to legislate for peace, order and good governance in the territory, that being equivalent to a full legislative discretion as Parliament would have.
It's not one which the judges, the courts can test.
No,
It's not
in
just
the same way that we wouldn't test an act of Parliament. That's purely political. But I thought that the case that we're dealing with here is not dealing with an exercise of legislative authority, but of some other prerogative authority, not legislative in character.
Indeed so, but I cite Lord Roger in that context, and in addressing the issue of how, if at all, the courts could address themselves to the matter of good governance, which is the term used by the Lord President in this context.
Yes, thank you.
And to the same effect, essentially, as Lord Carswell, and I'll simply give the reference at paragraph 130C, which can be found at MS 2340. So I submit that although the Lord President and indeed Lord Brodie acknowledge the principle of non-justiciability and its application by reference to subject matter, they simply don't follow through and apply that test which they've identified, but instead slip into concepts of illegitimate purpose, good governance, legitimate or illegitimate political considerations, none of which are amenable, I submit, to determination by the court. But that brings me on to the question raised by Lord Kerr, which is directed to the circumstances in which, in this case, the Inner House felt that they could identify a purpose in respect of the prorogation. And in addressing that matter, it may be helpful just to remind your lordships of the passage which my learned friend Lord Panic took the court to in Belize. And in particular, the passage that was quoted, I think from Lord Walker's judgment, albeit it may have been a dissenting judgment. And it's found in the case of Das, which he took the court to. I have it at MS 3566.
Sorry, could you give me that reference again, please, the MS number?
I believe I noted it as MS 3566.
In the cherry bundle, is it, or because the cherry bundle goes up to 3171.
It's 1481 in the cherry bundle, I think. If it's Lord Justice Beatson,
Yeah.
Yes.
1481.
Apologise.
Sorry, but the Belize judgment in full is produced in the cherry bundle at 2035-27.
Thank you.
Sorry, Lord King, which one do you want us to look at?
Well, I'd be happy to find either of them. So if you'll bear with me for a moment, I will endeavour to do so. Yes, I'm sorry, it's tab 13 in the Scottish bundle, beginning MS 1481 as observed. But going to 3566, which is the internal pagination,
it's 1509 on the MS. It's the final paragraph.
It's the final paragraph, my Lord, is
It's a
quite
front
right,
of
in MS 1509.
Yes, thank you.
And references there made to Lord Walker in Belize Alliance and to the obligation that was referred to cooperate and to make candid disclosure by way of affidavit of the relevant facts and this is the important part in parenthesis, so far as they are not apparent from contemporaneous documents which have been disclosed, the reasoning behind the decision challenged in the judicial review proceedings. And I draw particular attention to the observation, so far as they are not apparent from contemporaneous documents.
Yes, I mean, I see now that this was not the main judgment in which Lord Walker dissented, but it in fact was a preliminary hearing. So I think my point was a bad one.
Now, there was correspondence between the Government Legal Department and the agents acting in Miller on the matter of the production of documents. And if the court has regard to Miller Bundle at page 518, electronically, I believe we had 63. Too difficult for me. If we have regard to the bundle there, we will see the 581, I'm advised. We have a letter from the Government Legal Department of 4th September 2019 to Mishkins.
I'm so sorry, completely my fault. I haven't got the reference.
I have it in the Miller Bundle at page 518.
518. Is that in the second volume? Can you help me? Oh, yes.
I'm afraid if there is an MS number, I don't have it.
Yes, I have it.
Right at the back of the trial bundle.
It is in the trial bundle. It's at the very end of the trial bundle.
Yes, thank you. I have it now.
And in that letter, which was sent in response to correspondence about the witness statement provided in this case and the disclosure that had been given, it said that we are satisfied, having reviewed matters in consequence of that correspondence, that it was properly made clear by GLD that thorough searches were required for information relevant to this claim, and so on. And then towards the end, for the avoidance of doubt, we consider that the reasons for the decision can properly be derived from those contemporaneous documents recording what was communicated to and by the Prime Minister, and especially the Cabinet Minute, and we have seen nothing to suggest that that is not so. Finally, in relation to the redactions made to the documents disclosed, we have nothing to add to the reasons given in the witness statement. We will take whatever steps the court may consider appropriate, remaining as we do concerned to assist the court in whatever way we can, and we have considered and reconsidered the duty of candour. However, our considered view is that both the witness statement and the disclosure exercise have been dealt with properly. So that was the background to how the matter was being approached in that context. And it is then perhaps useful not just to look at the documents that were produced, which quite exceptionally included a Cabinet Minute, but the way in which the Lord President recorded that documentary evidence that was laid before the court in Scotland. And that can be found if we go to the Lord President's opinion, first of all at paragraph 9. your lordships have that, there's a heading, the Respondents' Documents. And it says that on the eve of the hearing before the Lord Ordinary, the respondent produced a number of documents relative to what happened within the government. The first is a memorandum dated 15th August from Nicky de Costa, the Director of Legislative Affairs within the Prime Minister's office, to the Prime Minister. This reads as follows, and if I could just quote from the summary, the current session is the longest since records began, and all bills announced as part of the last Queen's speech have now received royal assent or are paused awaiting carryover into the next session. This makes it increasingly difficult to fill parliamentary time with anything other than general debates. As a new Prime Minister, there is an expectation that you will set out a refreshed domestic programme, and it would be natural to do so when the House returns in the autumn. As the first week's business in September has already been announced, I recommend dedicating the second to wash up on bills such as R&R. We would then prorogue sometime between the end of Monday 9th September and Thursday 12th September, allowing for the long-standing conference recess. I'll return to that point in due course, and return on Monday 14th October with the state opening of Parliament. And then the recommendation, are you content for your PPS to approach the Palace with a request for prorogation to begin with the period Monday 9th September and Thursday 12th September, and for a Queen's speech on Monday 14th October?
Can I just ask, as a matter of information, in the first sentence of the paragraph, where it says that all bills announced as part of the last Queen's speech have either received royal assent or are paused awaiting carryover into the next session.
Yes, at the end of a session, it's possible for bills to be carried over so that they don't fall at the end of the session.
Yes, I appreciate that. So does that mean that the prorogation of Parliament imminently was anticipated?
Well, I think what it means is that at this stage, prorogation of Parliament is being contemplated, because the session of Parliament has run for nearly 2 years.
Yes, I mean, why would you pause a bill to await carryover unless you're anticipating imminent prorogation? I'm just asking.
Simply because if you're at the point where the session is 2 years long, and there's a question of whether or not you're going to go into recess or prorogation, you would consider what you're going to do with the bills. In other words, you would have to take formal steps to carry them over, or they would fall. Can I go on to paragraph 10, where the Lord President quotes under the heading Political Considerations from the same document. Finally, politically, it is essential that Parliament is sitting before and after EU Council. MPs and peers must be in a position to consider what is negotiated and hopefully pass the withdrawal agreement bill. If there is no deal, they need to have an opportunity to hear what you have to say and respond accordingly. And then at paragraph 11, the Lord President, understanding these documents, observed, the memorandum noted that in modern times, prorogation was usually less than 10 days, although there were longer periods for up to 21 days since 1980. Although the planned prorogation would be 34 days, the expected conference recess of 3 weeks would mean that only 1 to 3 days would be lost in the week commencing 9th September and 4 in the week commencing 7th October. There was no record of the House of Commons sitting in late September or early October since the start of the 20th century. I should say that up until 2002, the summer recess of Parliament always extended into October to cover the conference period. In 2002 and 2003, Parliament returned for a period of a few weeks at the beginning of September and then went into conference recess. That practice ceased, but then recommenced in 2010. And since then, as I understand it, Parliament has come back after the summer recess for 2 or 3 weeks at the beginning of September and then gone into the conference recess. And indeed, if we go over to paragraph 12, we can see the note applied by the Prime Minister, and it's in the context of what I've just said. The whole September session is a rigmarole introduced to show the public that MPs were earning their crust. So I don't see anything especially shocking about this proposition. As Nicky notes, it's over the conference season, so that the sitting days lost are actually very few. And then the Lord President went on to consider the further documents, and I'm not going to read them out at length at this stage, but essentially the fourth document was a redacted cabinet minute dated 28th August 2019, was essentially noting what the Prime Minister had decided. And at paragraph 15, the Lord President noted that this said, this timetable gave Parliament ample time to debate Brexit in the period before the October European Council on 17th to 18th October, and again in the run-up to the UK's departure date on 31st October. It was important to emphasise that this decision to prorogue Parliament for a Queen's speech was not driven by Brexit considerations. It was about pursuing an exciting and dynamic legislative programme to take forward the government's agenda. And not surprising that perhaps what was being anticipated there was some pushback for political purposes from other parties within Parliament who might seek to suggest that there was some alternative motive behind the prorogation of Parliament. Now, my learned friend, Lord Panic, then sought to place considerable stress upon the apparent absence of a witness statement from the Prime Minister.
Lord Keane, if we are leaving the documents produced, do we find in any of the, I think, 4 documents in all, an explanation of why 5 weeks was necessary for
Yes.
the opening of a new session and the Queen's speech?
Yes, my Lord, because it was going to encompass the conference recess period of 3 weeks, with the result that only 7 days would in fact be lost, only 7 sitting days would be lost to Parliament if it was prorogued during that period.
That might be said to be a possible defence to this election of 5 weeks. It doesn't explain why 5 weeks was chosen.
Well, the period of 5 weeks would also fall between the reporting periods under the Northern Ireland Executive Formation Act.
Right, but all of this could be done in 10 days or less, couldn't it?
Not if Parliament is in recess, and I'll come on to explain why that point is significant, and indeed in what respect the Inner House made a fundamental error in assessing these periods when having regard to what would happen and what could not happen during recess, because there was exhibited by their lordships in the Inner House a fundamental misunderstanding of what the position would be pursuant to parliamentary procedure.
Lord Keane, my other question would relate to Ms. de Costa's Spectator article, if you happen to have it at tab 32 of the English trial bundle. 201, I think.
Well, if my Lord would allow me a moment.
Of course. We're told this Spectator article is dated 29 June, and the important headline of Ms. de Costa's piece is, "Will Parliament be able to stop the next PM leaving without a deal?" And obviously one highlights in particular the last sentence of the second paragraph. We've already seen this game played out with prorogation, admittedly a nuclear option. So my question is, would the court be entitled to consider that background when it considers Ms. de Costa's submissions to the Prime Minister in the documents provided?
Well, with respect, my Lord, Mr. Costa wrote that in her capacity as an individual working for a private firm, not as Director of Legislative Affairs at number 10. So it seems to me that it would be perfectly appropriate for her to speculate in her private capacity as to what Parliament could do might do, and indeed there are other articles referred to by the Lord President at paragraph 7 of his opinion, where it was mooted, for example, in the Daily Telegraph, that if Parliament was prorogued up until or beyond 31st October, then it wouldn't be able to prevent a no-deal Brexit. Now, we know that never happened, and we know that, in fact, Parliament legislated expressly to address the question of our exit from the EU on 31st October without a deal. But I'm sure one could go through any number of media articles, political blogs, and others during this period when a great deal of speculation was going on. But what we are looking at here are the concrete reasons which were given to the Prime Minister and acknowledged by the Prime Minister for the purposes of this prorogation. And in my submission, the documents themselves speak for themselves. They don't require a witness statement, albeit it was contemplated by my learned friend Lord Panic that this might have given the opportunity for the Prime Minister to be cross-examined upon the matter of prorogation. But having noted that those documents were there, what is perhaps most surprising is the way in which the Inner House departed from the circumstances disclosed in those documents and sought to infer some alternative, sometimes referred to as clandestine, purpose. But before coming on to address that, I should also just notice the point made by the Lord President about the absence or otherwise of a witness statement, because my learned friend Lord Panic made some placed some considerable weight upon this. If you could turn to paragraph 55 of the Lord President's opinion. He said, thirdly, there is remarkably little said about the reasons for prorogation in the Respondents' pleadings. Although the court would not expect an affidavit, the Scottish equivalent of a witness statement, from a government minister or official testifying to the reason, and he then refers to the procedure in Belize, Lord Walker delivering the opinion of the minority at paragraph 86, it would expect the averments in the Respondent's answers setting out that reason. So it was not the view of the Inner House, Lord Brodie and Lord Drummond-Young say nothing about this, that somehow the absence of an affidavit was of any significance or led to the drawing of any adverse inference whatsoever in the context of the Scottish procedure. And that reflects, as I would suggest, the point made by Lord Walker in the passage in parenthesis, where he says, where the documents speak for themselves, there will be no requirement for a witness statement. And the Lord President, having set out the documents at length, goes on to observe that the court did not require an affidavit in these circumstances. But what the Lord President did was to determine, notwithstanding the terms of the document or documents, that the particular circumstances pointed to a true reason which could then be impugned. That was the term he used, true reason, at paragraph 53 of his opinion at MS 1210. And if I could briefly give the court references to the approach which the Inner House took to this, the Lord President at 56, MS 1211, referred to what he termed the extraordinary length of the prorogation. And he put that in context. He said the extraordinary length, 5 weeks, not 7 days. Lord Brodie referred to the lengthy period of prorogation at paragraph 90, MS 1234. Lord Drummond-Young refers to the same matter at paragraph 122, MS 1252, and said no rational explanation for the length of prorogation had been given. but with the greatest of respect, such an explanation had been provided and is indeed provided for in the documentation and had been recorded by the Lord President in his opinion at paragraph 11. Namely, that because the prorogation would cover the conference recess period, the number of sitting days lost would be up to 7.
Why did it need to cover the conference sitting?
I'm just going to come on and elaborate upon that, if I may. But the point I make at this stage, how can the court draw an inference of improper motive in the face of that evidence? And that is particularly glaring in circumstances where the Lord Ordinary did not feel that there was any basis for going behind the primary documentation, in circumstances where we know the divisional court did not consider that there was any basis for going behind the primary documentation, and where the inner house comes to rely upon inferences which might be contemplated where there's a gap in the evidence, but here there was no gap in the evidence. The inner house conclusion rejects wholesale the documentary evidence that is referred to.
I think you can say that they rejected, but they didn't find, as the Lord President put it, a practical reason for the prorogation. And I'm still hoping that you're going to tell me what it is.
I'm still hoping to get there in just a few moments, my lord. But the point I make is that a perfectly rational reason having been provided for prorogation, taking into account the conference recess, the inner house seeks to explain it away by emphasizing an artificial distinction between prorogation and recess. And this is where the inner house fell into a fundamental error or misunderstanding. At paragraph 96, Lord Drummond-Young, this is MS 1237, observed that if Parliament is in recess but not prorogued, it may reconvene itself. At paragraph 107, lest there be any doubt about this, MS 1243, he said that recess can be revoked by Parliament at any time. At paragraph 119, he said of recess, Parliament can resume sitting at any time. That's MS 1250. And then the Lord President, at paragraph 56 of his opinion, MS 1212, Parliament, when in recess, may recall itself. And then Lord Brady, perhaps a little less explicit, at paragraph 91, MS 1234, said Parliament has a right to sit if it wishes to. My lords, if Parliament is in recess, it cannot reconvene itself. It cannot revoke recess. It cannot resume at any time, and it cannot recall itself. Standing Order 13, which can be found at tab 33 of the Miller Supplementary Bundle, provides that if the House of Commons is in recess, and for convenience, you'll also find it referred to at paragraph 121 of our written case, because it's summarized there. But Standing Order 13 provides that if the House of Commons is in recess, it can only be recalled at the request of the executive. And then it is for the Speaker of the House of Commons to determine if the executive request is in the national interest. Interesting, the standing orders for the House of Lords are rather different. Standing Order 17 of the House of Lords provides that the Speaker can recall Parliament. Now, there are 2 points to be made here. One, once Parliament went into recess. It wasn't open to Parliament to return at will. And two, if the executive had wanted to prorogue Parliament while it was in recess, it would have had to recall Parliament to prorogue it. And if the Speaker had decided it wasn't in the national interest, that could not have been done. And therefore, prorogation would have been delayed until after the conference recess period, which ran for about 3 weeks, into and including the first week of October. So once you factor in that point and appreciate the fundamental misunderstanding or error made by the inner house, you can go back to what the Lord President said at paragraph 11 of his opinion. In summarizing the documents that were before him. That's at MS 1190. And this is the Lord President recording the documents before him. Second line, although the planned prorogation will be 34 days, the expected conference recess of 3 weeks would mean that only 1 to 3 days would be lost in the week commencing 9th September and 4 in the week commencing 7th October. A total of 7 days. And yet, later in his opinion, he expresses his opinion about the extraordinary length of the prorogation on the basis that it's 5 weeks rather than 7 days. It was in reality 7 sitting days that were going to be lost, not 5 weeks of sitting days. And that, in response to the inquiry from the Lord Kerr, is
Why
why
lose even 7 days? What is the practical reason? That's what the Lord President poses.
With respect, that is not the question the Lord President poses at all. He poses the question of why they've lost 5 weeks instead of 7 days.
Well, let's suppose it is 7 days. Why lose 7?
Why should it not be 7? Why should it be 1 day? Why should it be 14 days? How is the court going to judge what is an appropriate period for a prorogation determined by the executive in exercise of the royal prerogative?
Is there anything in the documents which is directed specifically to the reason that any days, whatever, should be lost?
I've taken your lordship to the documents. The point that the Lord President relies upon is that 5 weeks have been lost instead of 7 days. It is perfectly clear, once you understand how recess operates, that there was no loss of 5 weeks of sitting time for Parliament. There was a loss of a maximum of 7 sitting days.
Can you help me with some really basic practical questions? Could Parliament have decided not to go into recess?
Theoretically, yes, although there was no record of it not being in recess during this period since the beginning of the 20th century.
No, but the theory is it could have decided not to, in which case
recess, yes.
The number of days lost would have been the larger number that we've been looking at.
If it had decided not to go into recess. But as I say, there was no record of it not having done so.
Second question, really practical question. Could it have been a prorogation from the date after they came back from the recess? Would that have, that would still have worked, wouldn't it, in terms of
They would have had to wait until it had returned. It was contemplated that its return would be after the first week in October. So you would go into prorogation. And even if you limited the prorogation to a few days, you'd be returning on about the 14th of October, which is the end date of the prorogation that was actually granted.
But it could have been a prorogation from that later date and still achieved the 14th of October.
It could still have achieved the 14th of October, but Parliament would have been in recess for the preceding 3 weeks. Well, let me be careful. The House of Commons would have been in recess.
Yes, the House of Commons and the House of Lords don't go into recess at the same times, necessarily.
They sometimes
Sometimes they
coincide,
do and sometimes they
but
don't.
they don't necessarily coincide. And if, for example, the House of Commons decided not to go into the conference recess, but the House of Lords did, Parliament couldn't pass primary legislation anyway.
No, but the committees would be able to
But the
continue.
committees can function during recess. To what extent they do when people are away at parliamentary conferences may be an issue of fact, but they could. And written questions could be submitted during recess. But
Thank
not
you very much
prorogation.
indeed.
Those are both important forms of accountability.
They are forms of accountability, but given the speed with which the committees operate, I question whether, during a period of 3 or 4 weeks, one was going to see a startling change in the operation of a committee.
But questions would be
Well, questions could be submitted, written questions could be submitted, and we would be responded to in writing. But that's the extent of it during recess. But the point I make is that it is quite plain that the Inner House, in addressing this issue and deciding that it could impugn the decision of the Prime Minister, was proceeding upon a fundamental misconception about how Parliament operated.
Given the importance of this, I'm not sure it's... Well, it's striking that Mr. Costa's minute refers to a number of considerations bearing on timing, and indeed gives an explanation of a kind that I think Lord Kerr may be looking for, which aren't referred to in the Lord President's opinion. I mean, for example, she advises the Prime Minister against having the Queen's speech a week earlier on the 7th of October because
of the
key
SNP
votes
conference.
because of the SNP conference. And she gives an explanation about proroguing in the period of the 9th to the 12th of September to do with the practicalities of wash-up of the existing bills.
In addition, she says at paragraph 10, with regard to the date for the Queen's speech, number 10 and the legislative-focused parts of Whitehall and the business managers have long had a mid-October date in the diary, and it has been a central planning assumption. However, additional work now needs to be undertaken so that the Queen's speech is shaped to your domestic priorities. In my view, the week commencing 14th October is achievable, but any earlier is extremely pressured. And then, on a lesser note, a Queen's speech on 7th October will place key votes on the days of the SNP conference. And then at 14, finally, politically, it's essential that Parliament is sitting before and after the EU Council, and that's the passage I referred to before. So there is a detailed analysis with respect to why the prorogation, standing the conference recess, should take us up to the 14th of October, although in theory, I accept the observation made by your ladyship that you could have come back at the end of a conference period after the first week of October and sort of a Queen's speech and then prorogue Parliament. But there are a variety of reasons given as to why that would not be considered appropriate.
You know, people will have to read it, but there is quite a lot in this minute to do with reasons for the timing advice that was given.
And yet all of it is cast aside by the Inner House in place of an inference which isn't required because the documents speak for themselves, and in circumstances where they didn't consider it necessary that there should be any additional affidavit or witness statement to speak to the documents, which were plain on their face for the reasons that we've just considered. And yet,
I've mislaid where Mr. Costa's memo is. Could you please remind me? I'm sorry.
I believe it's 317 in the Miller bundle.
317.
In the trial bundle. And electronically, if you've got the Miller memory stick, which I haven't.
Yes, thank you.
381. MS 381.
I was looking for it in that bundle, but I mislaid it. Thank you so much.
would just add, because the question of Parliament voting against a conference recess was raised, or not having a conference recess. That's a matter of fact that was not explored. I do notice that there are a number of members of Parliament who are parties to the Scottish action, and the first petitioner provided 3 affidavits on various dates. The first, very detailed, the second dealing more with the issue of costs, and the third dealing in some detail about the issue of interim relief. And having examined those affidavits, I can find no hint or suggestion that Parliament would not have gone into conference recess. And yet, Lord Brodie was able, he felt, to describe the period as egregious. The Lord President was able to describe it as extraordinary, but only because, as I say, of a fundamental misunderstanding of how Parliament operated in the context of recess. My Lords, given the time, I would seek to rest my submissions there. In my respectful submission, it is appropriate that the interlocutor of the Inner House should be recalled. And in any event, even if the court were to be against me on that, I would submit that it should recall part 4 of the interlocutor for the reasons which I sought to give earlier. And having noted what Lady Hale said about trying to agree a form of words for an undertaking, I will speak to my own friend, Lord Plannock, on that topic. And see if
And
we
no
can
doubt to
produce-
those instructing you.
I don't think Mr. O'Neill is ever readily ignored in these circumstances. You may rest assured on that point. Unless there are any further questions from the court, I would rest my submission. I'm most obliged.
Thank you very much indeed, Lord Keane. Mr. Webster? Well, with congratulations to everybody for the precision of their timing, the court will now adjourn and look forward to hearing from you, Sir James, tomorrow morning at 10:30.